Okay, I'm gonna read trusts. Trust overview. This is only 8 pages, which is a lot better than the 70-page outlines that I have been reading. So, let's just get this done. And let's see to it that that'll work. Like, for essays, for the sake of writing essays, that's all we've got to know. It's enough to pass essay writing, which I might read the essay writing outline too. So let's start. In brief, a trust is a fiduciary relationship with respect to property in which one person, the trustee, holds legal title to the trust property, the res, subject to enforceable equitable rights in another, the beneficiary. It is a device whereby one or more persons manage the property for the benefit of others. The trust must have a valid trust purpose. The trustee ordinarily has legal title to the property, and the beneficiaries have equitable title. The testator or grantor or settlor who creates an express trust is the settlor, who must have had the intent to create the trust. Consideration is not required for the creation of a trust. In fact, trusts are usually created gratuitously. That's it for the intro. Requirements of an express private trust. Settlor with capacity and present intent to create a trust. Settlor with capacity and present intent must intend trust to take effect immediately, must express intent by words or conduct while settlor owns the property. Precatory expressions, hope, wish, suggestion results in inference that no trust was intended, but inference may be overcome by other evidence. Trustee. Failure to name a trustee or failure of trustee to accept or qualify does not defeat a testamentary trust. Court will appoint a trustee. Inter vivos trust will fail without trustee because there can be no valid delivery and transfer of trust property. See below. Trustee must have duties, and the settlor may declare himself trustee. Trust property res. Property may be of any type, including future interests. 2, must be property that settlor has the power to convey, and 3, must be described with certainty. Beneficiaries must be capable of taking and holding title to property, must be definite, susceptible of identification when their interests come into enjoyment. Example, friends is insufficient. Notice is not required, but beneficiary must accept. Acceptance is presumed. Valid trust purpose. Trust or provision must not be illegal, impossible to achieve, contrary to public policy, for example, to induce crimes, tort, divorce, child neglect, or intended to defraud settlers' creditors based on a legal consideration. Effective invalid condition subsequent. Condition stricken, but trust is valid. Effective invalid condition precedent. Condition stricken, but court decides whether interest is valid or fails. Formalities. For an inter vivos trust, which is created during the settlor's life, the formalities include the declaration of trust by property owner that he holds in trust, or transfer of property by the settlor to the trustee. No writing is required unless the trust involves land. Testamentary trust, which is created by the settlor's will. A. Essential terms must be ascertained from the will, incorporated document, facts of independent significance, or exercise of power of appointment, I guess, are examples. B, secret trust, absolute gift, but trust intended. A constructive trust is imposed as a result of your secret trust. Semi-secret trust, gift and trust without beneficiary, resulting trust for testator's heirs. Charitable and honorary trusts. A charitable trust is a purpose to benefit the public. It must be to benefit the public, such as poverty relief, education, or health. Must have indefinite beneficiaries. May be perpetual. The rule against perpetuities does not apply. RAP does not apply to limitations that shift beneficial interest from one charity to another, charity to charity exception. RAP does apply to a limitation shifting the interest from private use to charitable or from a charitable use to a private use. Enforceable by Attorney General, not settler or beneficiaries. Cypress. If settler's intended purpose is impracticable, unlawful, or wasteful, the court substitutes a new charitable purpose. Must A, for Cypress, A, must find settler had general charitable intent, not just interested in the name charity. The court will select another purpose as near as possible to the charitable intent, and the UTC, I guess, is the Uniform Trust Code. Settler, under that code, the settler's general charitable intent is presumed, and application of Cypress is mandatory. Honorary trusts is neither private, is not for a charitable purpose, but to private beneficiaries who can enforce the trust. For example, trust for pets, trust for graves, trust for houseplants. 2, not enforceable, but trustee may choose to carry it out. Under UTC, honorary trust is enforceable for 21 years. 3, if trustee does not carry it out, a resulting trust imposed for settler's estate. Part 4, transfer of beneficiaries' interest and creditors' rights. Beneficiary's equitable interest is alienable. Beneficiary may voluntarily transfer interest in trust, and his creditors may levy on his interest. However, the spendthrift trust, the beneficiary's equitable interest is alienable. Usually, yes. If you have a spendthrift trust, however, provides that the beneficiary may not voluntarily or involuntarily transfer his interest. For example, cannot sell or give away interest, and creditors cannot breach it. It is not valid if the settler is also a beneficiary. However, there's a modern shift that in some states. And third, under spendthrift trust, dependents, government, those supplying necessities may be able to reach the protected interest. Discretionary trusts. Trustee has discretion to pay or withhold income or principal. Before trustee makes discretionary payment, interest cannot be reached by the creditors. Oh, that's not what I thought. After trustee elects to make payments, must pay creditors directly if he has notice, unless there is a spendthrift restriction. Okay, that's more along with what I thought. Both of those statements are true. So the trustee has to elect to make payments before the creditor can attach the discretionary payment to the beneficiary, unless there's a spendthrift restriction that's effective. Support trust cannot be assigned or reached even without a spendthrift clause. Don't define a support trust, though, while you're at it. It's for the support of someone else. It requires like a special clause. There's like usually 3 different kinds or so. And they literally don't appear to be defining it in here. Sometimes it can be for like health expenses or education. I guess it's not that important. Let's keep going. Part 5, modification and termination of trust. By settlor. Must reserve right to revoke or modify under the Uniform Trust Code, trust presumed revocable. And 2, power to revoke includes power to modify. By beneficiaries. May terminate or modify if A, all beneficiaries consent, watch for remote unborn beneficiaries, and B, if will not, if and beneficiaries may terminate or modify if and only if it will not interfere with the material purpose of the trust. And you look at the Claflin case, examples of purposes precluding termination is if the distribution is called for at a specific age that the beneficiary reaches, preserving property for remainderment, or protecting beneficiary from their own poor judgment. Now, beneficiaries may also, under beneficiaries, the second example is the joinder of the settlor waives the material purpose, or third, the spendthrift trust cannot be terminated without the settlor's consent by the court. And this is a modification or termination by the court now. 1, may terminate if trust purposes accomplished or become illegal or impossible. And 2, the court may modify if changed circumstances make compliance incompatible with trust purpose. Like, you got a charitable trust to preserve like a species from extinction, and then they would go extinct. You can't, your trust can no longer do what it was intended to do. Trust administration. Powers of the trustee. Power to sell and lease unless limited by trust instrument. 2, power to incur expenses. Necessary and ordinary management expenses are allowed. The power to improve property, usually not inferred. And lastly, third, power to borrow money must be granted in trust instrument. Those are kind of general powers of the trustee under trust administration. The duties of the trustee under trust administration is care, loyalty, duty to separate, earmark trust property, duty to perform personally, cannot delegate administration of the trust, duty to preserve property and make it productive. And then there's some about the trustee's liability, a little about the allocation of receipts and expenses, Uniform Principal and Income Act, before getting to will substitutes and resulting in constructed trust. So again, what are the duties of the trustee? Care is a standard that of reasonably prudent person managing their own property. That's the standard of care. Loyalty requires no self-dealing, cannot buy assets from or sell assets to the trust, cannot borrow from the trust or loan to the trust, cannot personally gain through position, corporate trustee cannot buy but may retain own stock. If duty breached, beneficiary may set aside transaction, recover profit, or ratify the transaction. And settlor can waive self-dealing restrictions, like we saw as one of the powers to borrow against the trust. 3, duty to separate trust property, no commingling of the trustees own property with the other trust property. Commingled property lost or destroyed presumed to be trustees. If portion of commingled assets increases in value, presumed to be trust assets. And if the portion of commingled assets declines in value, it's presumed to be the trustee's assets. It talks about the duty to perform personally, and you can't delegate the administration of the trust, which I think now you can, or at least you can as it relates to investment decisions. There's a duty to preserve property and make it productive. Investments must be prudent. Trustee must use reasonable care, skill, and caution. Trustees with special skills are held to a higher standard. Trustee must diversify the investments. Investment decisions may be delegated if a prudent trustee would do so. And prudence is evaluated in terms of the overall strategy. Trustees' liability. Liable. Okay, so what did I just say? Special skills are held to a higher standard. They must diversify, and their decisions may be delegated if a prudent investor would do so. Now, as far as prudence is evaluated in terms of overall strategy. Okay, so moving to part C of trust administration is the trustee's liability. Trustee is liable to beneficiaries for breach of trust, and they surcharge. The beneficiary will engage in a surcharge action against the trustee, or an action for surcharge. Now, 2, losses from one breach may not be offset against gains from another. Defenses. Latches or express or implied consent to the breach by beneficiaries. Exculpatory clauses relieving trustee of all liability for bad faith, intentional breach, or recklessness are void. I didn't know that. I thought they were totally acceptable. Except for maybe when they're in bad faith, intentional, or reckless. Trustee liable to third persons for contracts and torts, but usually entitled to indemnification. So we're on page 7 out of 8. And section D, like I said, the allocation of receipts and expenses, Uniform Principal and Income Act, UPAIA. Trustee must administer trust impartially, must be fair to all beneficiaries. Interest and divided income to income beneficiary. If such distribution does not effectuate trust purpose and is unfair, the trustee may adjust between principal and income. Receipts, income, rental income, interest on bond or CD, money received from equity, liquidating assets and mineral rights, and the 10% rule. So that's interesting. Okay, so the receipts and expenses. They're kind of just hanging out here under the UPAIA. I feel like this has to do with the duty of accounting. So for income, I guess that needs to be accounted for. Talking about rental income, interest on bond or CD, money received from entity, liquidating assets and mineral rights, 10% rule. I don't know what the 10% rule is. Now, for principal, the proceeds of sale of asset, eminent domain awards, capital gains, property other than money received from entity, insurance proceeds, where trust is beneficiary, liquidating assets and mineral rights, and this is 90%. I don't know what that means. Income. So under expenses, income is written next here. 1/2 trustee and consultant compensation, 1/2 accounting and legal expenses, ordinary expenses, interest payments on debt, ordinary repairs, taxes, and insurance premiums. And principal under expenses is 1/2 trustee and consultant compensation, 1/2 accounting and legal expenses, principal payments on debt, and environmental costs. Will substitutes, revocable trusts. Interest passes during life but becomes possessory at death. That's your revocable trust. Under revocable trust, you have secondarily, there's a pour over from will to a revocable trust. Trust A. Trust may be established before, after, or concurrently with the will. Trust, but not, before, after, or concurrently. Trust must be amendable and revocable. Gift is valid even if trust is unfunded during the settler's lifetime in the circumstances that it comes from, that the assets are going to pour over on the settler's death pursuant to the pour over will. Life insurance trusts, contingent beneficiary trusts allowed. For example, proceeds to A, but if A does not survive, to B in trust for my children. Assignment of policy trust allowed, and sign policy to party to hold in trust. That's what you do with life insurance in trust. Taten trust bank accounts. Trustee depositor has full rights during lifetime, revoked by withdrawals or any other lifetime act, including intent to revoke or by will. Subject to depositor's creditors' claims, automatically terminates if beneficiary predeceases the depositor. Resulting in constructive trusts. Resulting trusts. Purchase money resulting trusts. Person taking title did not supply consideration. Sole duty is to convey title to one furnishing consideration. No resulting trust presumption if parties are closely related. Failure of express trust. Resulting trust arises with settler as beneficiary. An excess corpus. If the trust property remains after purpose is fulfilled, a resulting trust for the settler arises. And lastly, constructive trusts are equitable remedies to prevent unjust enrichment, such as employed when there's theft or conversion, or contract relations stained by fraud, duress, undue influence, mistake, or interference with contract relations. Breach of a fiduciary duty, for example, attorney, client, director, corporation, trustee, beneficiary, or the breach of fraudulent promise by one in confidential relationship, promise concerning will or inheritance, or promise to forego foreclosure bid. That's everything within the overview and sonnet. I don't really have the ability to immediately start recording the essay outline because I'm logged out. Oh, wait a minute. Totally logged out. Wait, so you're going to record something else soon?